I looked at the man across the bench and understood, with the kind of clarity that only comes after 43 years of doing this work, that I was about to watch someone mistake confidence for immunity. He had his phone out, not hidden under the table, not tucked discreetly in a pocket, but out on the defense table in full view, his thumb moving in small, deliberate circles across the screen. He looked up once, briefly met my eyes with something that wasn't quite defiance, but wasn't respect either, and went back to scrolling. My name is Judge Judith Scheinlin. I have presided over more than 20,000 cases in courtrooms across 3 states. I have seen wealth, I have seen power, and I have seen the peculiar arrogance that comes when someone confuses the two with justice. What I had not seen until that Tuesday morning in March was someone look me directly in the eye and say the words, "My time is money," as though that phrase carried legal weight. If you believe that no person, regardless of how much they earn per hour or how many employees report to them, gets to treat a court of law like an inconvenience they can simply purchase their way out of, subscribe right now. Because what I am about to tell you is a lesson in what happens when someone forgets that the one currency that holds no value in my courtroom is entitlement. The case file in front of me was thin. A tenant dispute. Samuel Chen, a 68-year-old former software engineer, was suing his landlord for the return of a security deposit and compensation for what Mr. Chen described as systematic harassment designed to force an eviction without cause. The landlord was Dylan Reeves, founder and CEO of a company called Velocity Stream, a tech firm that had been featured in 3 separate magazine profiles in the past 18 months, under headlines like The Disruptor, Who Refuses to Slow Down, and How One Founder Built a $400 million empire in 4 years. I had read none of those articles. What I had read was Mr. Chen's complaint typed on a machine so old the letters printed unevenly, some darker than others, and filed in person because Mr. Chen did not own a computer capable of submitting documents electronically. Samuel Chen had lived at 1247 Oakmont Avenue for 19 years, not 19 months. 19 years. He had moved into that rent-controlled apartment in 2004, 2 years after his wife died, because the building was 4 blocks from the library where he volunteered on Tuesdays and Thursdays teaching older adults how to use email. He paid $1,340 per month, the same amount he had paid since 2011, protected under the city's rent stabilization ordinance. He had no children. His sister lived in Oregon. He received $1,890 per month from Social Security and a modest pension from the engineering firm where he had worked for 31 years before it dissolved in a merger. He did not travel. He did not own a car. He had a bus pass, a library card, and a small savings account he kept for emergencies that held, according to the financial disclosure he'd been required to submit, $11,200. Every Tuesday and Thursday, Mr. Chen walked to the library. He left his apartment at 9:15 in the morning, carrying a canvas messenger bag his wife had given him in 1998, the year they celebrated their 30th anniversary. Inside the bag, he kept a spiral notebook, 3 pens, and a small container of the hard ginger candies he handed out to students who grew frustrated with the keyboard. He taught beginners, people in their 70s and 80s who had never touched a mouse. He showed them how to open an email, how to attach a photo, how to reply without accidentally sending a message to everyone in their contact list. He did this for free. He had been doing it for 12 years. In October of the previous year, Velocity Stream purchased the building at 1247 Oakmont Avenue as part of what the company described in a press release as a targeted acquisition strategy focused on undervalued urban assets in high-growth corridors. 3 weeks after the purchase, Mr. Chen received a letter informing him that his rent would be increasing to $4,100 per month effective January 1st. The letter was polite. It thanked him for his tenancy. It cited a clause in the lease regarding substantial capital improvements that allowed for rent adjustments beyond the normal stabilization limits. It provided a phone number he could call with questions. Mr. Chen called that number 6 times. He left messages. No one called back. In November, the building's front door lock was changed without notice. Mr. Chen's key no longer worked. He stood outside for 40 minutes before a neighbor let him in. When he contacted the management company, he was told the locks had been upgraded for security purposes and that new keys would be distributed within 5 business days. He received his key 9 days later. In December, the heat stopped working in his unit. The thermostat, which had always been somewhat unreliable, now did nothing at all when adjusted. He called the management company. He was told a technician would be sent. No technician came. He called again. He was told the issue was being prioritized. The temperature in his apartment during the coldest week of the year was 53 degrees. He slept in 2 sweaters and the wool coat his wife had bought him in 1996. In January, his rent did not increase to $4,100, it increased to $4,850. When he called to report what he assumed was a clerical error, he was told the amount was correct and reflected updated market analysis. He could not pay it. He did not have it. He paid what he had always paid, $1,340, and attached a letter explaining that he was contesting the increase under the rent stabilization ordinance. 2 weeks later, he received an eviction notice for non-payment of rent. He sat in my courtroom with his back very straight and his hands folded on top of that canvas bag. He did not fidget. He did not look around. He looked only at me, and when I asked him to explain why he was here, he did so in 4 sentences, clearly and without emotion. He had lived in his apartment for 19 years. He had paid his rent on time every month. His landlord was attempting to evict him for refusing to pay an illegal rent increase. He was asking the court to enforce the law. That was all. Dylan Reeves arrived 14 minutes late. He did not apologize for his lateness. He walked into the courtroom the way someone walks into a restaurant where they have a reservation, with the casual expectation that his presence had been anticipated and that accommodations would be made. He wore a navy suit with no tie, a white shirt with the top 2 buttons undone, and sneakers that I later learned cost $740. He was accompanied by an attorney, a young woman in her early 30s, who carried a leather portfolio and looked at Mr. Chen exactly once, briefly, before turning her attention back to her client. Mr. Reeves sat down. He did not look at Mr. Chen. He did not look at me. He looked at his phone. I let it go. I let it go because sometimes people are nervous, and nervous people do thoughtless things, and I have learned over 4 decades that the first small disrespect is often unintentional. I asked Mr. Reeves if he had reviewed the complaint. He nodded without looking up. I asked him if he disputed any of the facts as Mr. Chen had presented them. He said, still looking at his phone, "We dispute the characterization." I asked him to elaborate. He gestured vaguely toward his attorney, who opened the portfolio and began to explain that the rent increase was lawful under a provision that allowed adjustments when a property underwent capital improvements valued at more than 30% of the building's assessed worth. I asked what improvements had been made. She listed them: new locks, upgraded electrical panels, exterior painting, lobby renovation. I asked when the work had been completed. She said some of it was still in progress. I asked if the tenants had been notified in advance. She said notification was sent via email to all units. I asked if Mr. Chen had an email address on file. She hesitated. She looked at her client. Mr. Reeves looked up from his phone for the first time and said, "That's not really our problem, is it?" I did not raise my voice. I did not slam my gavel. I sat back in my chair and said very clearly that in my courtroom, whether or not a 68-year-old man without a computer received legally required notice was absolutely unequivocally his landlord's problem. Mr. Reeves put his phone down. He smiled. It was not a warm smile. It was the smile of someone who has just realized they are going to need to explain something simple to someone who doesn't understand how the world actually works. He said, "Your Honor, I run a company that does $43 million in revenue per quarter. I have 600 employees across 4 offices. I'm here because my attorney told me I had to be here. But frankly, this entire situation is a waste of my time and a waste of this court's time. Mr. Chen is living in a rent-controlled apartment in a neighborhood where market rate for that unit is $7,200 a month. We offered him $4,850, which is a discount of 30%. If he can't afford it, that's unfortunate, but it's not illegal." He picked up his phone again. He looked at me the way you might look at a clerk who's taking too long to process a return. He said, "My time is money, Your Honor. Can we move this along? If you can feel where this is going, if you can already sense what is about to happen when someone mistakes a courtroom for a boardroom, hit subscribe now. Because what comes next is something I have wanted to do for a very long time." I let the silence sit. I counted to 7. No one moved. Mr. Chen sat with his hands still folded. Mr. Reeves's attorney stared at her portfolio. Mr. Reeves looked at his phone, and I understood in that moment that he genuinely believed the conversation was over, that he had stated his position, and we would now proceed to whatever minor inconvenience remained before he could leave. I asked him to put the phone away. He did not. I asked him again. He sighed, the kind of sigh you make when someone is being unreasonable, and he set the phone face down on the table, but kept his hand on it. I asked his attorney if she had photographs of the capital improvements that justified the rent increase. She did. She handed me a folder containing 12 printed images: new locks, fresh paint, a renovated lobby with modern lighting, and pale gray walls. I asked when the lobby renovation was completed. She said November. I asked if the heat in Mr. Chen's unit had been functional during December. She did not answer. I asked again. She said she would need to check the maintenance records. I told her I would wait. She opened her laptop. She scrolled. She clicked. She scrolled again. She said the record showed 3 service requests from Mr. Chen's unit in December regarding heating issues. She said a technician had been dispatched on December 19th. I asked what the technician's report said. She read from the screen, thermostat functionality confirmed, no action taken. I asked if the technician had entered Mr. Chen's unit. She said the report didn't specify. I asked Mr. Chen. He said no one had knocked on his door, no one had called, no one had entered his apartment. He said he had been home all day on December 19th because he was too cold to go outside. I asked his attorney if she wanted to revise her statement about the technician. She said the report was what the report was. Mr. Reeves picked up his phone again. I told him to put it away. He looked at me. He said, I've been here for 40 minutes. I have a meeting at 11. Is there any way we can expedite this? That was the moment. Not the arrogance of the earlier comment, not the dismissiveness toward Mr. Chen. This, the assumption that a court of law operates on his schedule. I asked him if he understood where he was. He said he understood perfectly. I asked him if he understood that this was not a negotiation or a business meeting, but a legal proceeding in which he was the defendant. He said, respectfully, Your Honor, I understand that, but I also understand that my company generates approximately $12,000 per hour in value, and every hour I spend here is an hour I'm not spending growing that value. So yes, I would very much like to expedite this. He did not raise his voice. He was not rude. He was simply stating what he believed to be a fact. His time was worth more than this. I pulled the file toward me. I opened it. I read aloud the clause in the city's rent stabilization ordinance that requires landlords to provide written notice of capital improvements at least 90 days before implementing any rent increase, and to provide that notice via certified mail or personal delivery to every affected tenant. I asked if Mr. Chen had received certified mail. He said he had not. I asked if anyone had personally delivered notice to his door. He said they had not. I asked Mr. Reeves' attorney if she had evidence to the contrary. She said the email constituted notice. I read aloud the section of the ordinance that specifies acceptable methods of notice. Email is not among them. I asked if she had anything else to present. She did not. I asked if the lobby renovation, which cost $48,000 according to the invoice she had submitted, had been completed before or after Mr. Chen received his eviction notice. She said before. I asked if the heat in his unit had been repaired before or after he refused to pay the increased rent. She said the record showed it was repaired in January. I asked Mr. Chen. He said the heat started working again on January 8th, the same day he received the eviction notice. I closed the file. I looked at Dylan Reeves. I said, here is what is going to happen. The rent increase is void. Mr. Chen will continue to pay $1,340 per month, as he has for the past 14 years, and that amount will remain fixed under the rent stabilization ordinance for as long as he resides in that unit. The security deposit, which you have refused to return despite multiple requests, will be refunded in full within 7 business days, along with interest calculated at the statutory rate from the date it was originally collected. That amount is $2,140. You will also pay Mr. Chen $4,800 in compensatory damages for the harassment and habitability violations documented in this case, the heat that did not work, the locks that were changed without notice, the repair requests that went unanswered. You will pay an additional $3,000 to cover his filing fees, his time, and the cost of replacing the belongings that were damaged when he had to sleep in a 53-degree apartment for 6 consecutive nights. Total amount owed to Mr. Chen, $9,940. Additionally, you will personally write a letter of apology to Mr. Chen on company letterhead, acknowledging that the rent increase was improperly noticed and that the habitability violations were the result of your company's failure to maintain basic standards of property management. That letter will be submitted to this court within 14 days, and a copy will be provided to Mr. Chen. And finally, because you have made it very clear to me that you believe your time is more valuable than this proceeding, I am going to give you an opportunity to reflect on that belief. This case is continued for 6 hours. You will remain in this courthouse until 5 p.m. You will not leave the building. You will not conduct business. You will sit in the hallway outside this courtroom, and you will wait. The same way Mr. Chen has waited for returned phone calls, for repair technicians who never came, for a landlord who never once treated him like a human being whose dignity mattered. At 5 o'clock, you will return to this courtroom and you will confirm on the record that you understand that a court of law does not operate on your schedule, your convenience, or your valuation of your own importance. I have sat on this bench for 43 years. I have heard every excuse, every justification, every version of the argument that wealth entitles a person to different treatment under the law. It does not. It never has. What you revealed in this courtroom today is not intelligence or business acumen or efficiency. What you revealed is that you believe there are two kinds of people, people whose time matters and people whose time does not. You placed Mr. Chen in the second category because he is old, because he does not own a company, because he lives on a fixed income and teaches email to strangers for free. You are wrong. His time matters. His dignity matters, and the fact that you could not see that is precisely why you're going to spend the next 6 hours sitting in a hallway thinking about it. Mr. Chen did the work, he kept records, he saved letters, he filed his complaint properly and showed up on time. I didn't give him anything he wasn't already owed. I just made sure you couldn't ignore it. 4 months later, my clerk handed me an envelope. It had been delivered to the courthouse by messenger, addressed to me personally with no return address. Inside was a single piece of paper, a letter printed on plain white stock, written in the same uneven typewriter font as Mr. Chen's original complaint. It was short, 3 sentences. It said that he was still living at 1247 Oakmont Avenue, that his rent had not been raised, and that last week a technician had come to his apartment unannounced and replaced his thermostat with a new digital model that kept the temperature at exactly 72 degrees. At the bottom of the page, folded into the envelope, was a single ginger candy in a clear wrapper. I keep that letter in the second drawer of my desk under the trial calendar. I take it out sometimes when I am alone in chambers at the end of a long day, and I'm wondering if anything I do here actually changes the way people treat each other when they leave. Most of the time, I don't know. Most of the time, I sign the orders and close the files and hope that somewhere, in some small way, the machinery of accountability is working the way it is supposed to. But every now and then, I get a letter like that one, and I am reminded that justice is not an abstraction. It is a 68-year-old man who gets to stay in his apartment. It is a thermostat that works at his heat in December. Some people learn the lesson. Some people sit in that hallway for 6 hours and they think about what they did wrong. And they come back into the courtroom at 5 o'clock and they understand finally that no amount of money makes you exempt from basic human decency. And some people sit in that hallway and they count the minutes and they calculate the lost revenue and they leave still believing they were right. I cannot control which kind of person walks into my courtroom. I can only control what happens while they are here. This is what I know. Dignity is not a luxury. It is not something you earn by working hard enough or saving long enough or being patient enough. It is what you are owed simply because you are a person. And any system that forgets that is not a justice system at all. If this story moved you, share it, subscribe. Because there are more stories like this. One, and I am not finished.